As all too many celebrities know, it's been a common practice for over a century for police officers to take fingerprints and booking photographs of people they arrest. But what if a police officer wants to take an arrestee's DNA sample? Would the Fourth Amendment permit that without a search warrant? The United States Supreme Court addressed this issue in Maryland v. King. In 2003, an unknown assailant with his face covered broke into a woman's home, raped her, and fled. Police officers had no leads on the suspect, but did collect the perpetrator's DNA during a rape exam. In 2009, Alonzo King was arrested in a different part of the state and charged with first-degree assault. As mandated by a 2008 Maryland law, the arresting officers collected a DNA sample by rubbing a swab inside King's cheek. That law required DNA samples to be collected from defendants arrested for certain serious violent and sex offenses, including first-degree assault. King's DNA sample was then run through a DNA database. It matched the DNA taken from the rape victim. Based on the match, officers obtained a warrant to acquire another DNA sample from King, who by that time had entered a plea bargain to second-degree assault. The second DNA sample also matched the DNA from the rape. King was charged with rape. King moved to suppress the evidence of the DNA match to the rape case on the ground that the original DNA sample taken from him when he was arrested for assault was an unconstitutional warrantless search under the Fourth Amendment. The trial court denied King's motion, and he was convicted. On appeal, the Maryland Court of Appeals reversed King's conviction on the ground that Maryland's DNA collection statute was unconstitutional to the extent that it required DNA samples to be taken from arrestees as opposed to convicted defendants. The state successfully petitioned the United States Supreme Court to review King's case.